Major breaking news out of the United States Supreme Court. The United States Supreme Court has decided the United States versus Rahimi case as to whether or not facially, 18 U.S.C. 922 G8 that says that you cannot touch a firearm, you cannot possess a firearm if you are subject to a domestic violence restraining order. While that restraining order is in effect, the Supreme Court has ruled and held that facially that law is constitutional because there are some instances where that law could be applied consistent with the Second Amendment. This is the holding that we predicted here on this channel because they specifically said that if someone is found by a court to be a credible threat, a physically violent danger to others, then they can be disarmed. We knew that was going to be the holding. We knew that was going to be the rule. At least that's what we thought. And that is exactly what the Supreme Court did here. So there's a lot of good news here, even though I might have gone a little bit different path if I were on the Supreme Court, but I'm not on the Supreme Court, so I'm not going to answer the question like I'm on the Supreme Court. I'm going to tell you what the good and the bad and the ugly of this decision is right here and right now. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Terrorist Attacks Teach Americans About the Right to Bear Arms. We should always learn the lessons from the mistakes of others. The Israeli government made a lot of mistakes in disarming their ordinary citizens, making them vulnerable to this kind of attack. And again, you know the old saying, when seconds count, police are minutes away. Well, when in Israel, as I explained in the book, well, guess what? Unfortunately, when seconds counted in Israel, the IDF and the government were, in some instances, days away. So let us learn from the mistakes of the Israelis so we don't make the mistakes here in America and disarm ourselves. All right, folks, so this is major news. Major news. The U.S. Supreme Court has decided the Rahimi case. We've talked a lot about this case, and let's talk about the good and the bad and the ugly. So to begin with, let's start with what the Supreme Court actually said in what is a relatively short majority opinion. This is 8-1, 8-1. The only dissenting justice was Clarence Thomas, but you know, it is what it is. We got an 8-1 decision. We have to look at the majority opinion because that's the rule of law. The dissents ultimately don't count for the rule of law. So we have to focus on the majority opinion. And the holding of this case, which I think is very good, and we're going to talk about the benefits of this case, the good of this case. I think we dodged a metaphorical bullet here with what Merrick Garland was trying to accomplish. We'll get to that in 1 second. But the holding of this case by the U.S. Supreme Court is as follows. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. Since the founding, our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. As applied to the facts of this case, Section 922 G8 fits comfortably within this tradition. So that's the holding, and that is kind of what we expected because I didn't think there was any way we could possibly get to 5 votes that says that violently dangerous people that are found to be physically violent, dangerous to others, or possibly to themselves, although they didn't talk about themselves. Interesting. This decision is actually a little bit more narrow than I thought it might be in one sense. They went on to specifically say that, yeah, you can be disarmed. This conclusion is not a shock. I did think they were going to use the surety laws, which they did here, and the affray laws, which basically says you can't take a gun and go around terrorizing the people. And the surety laws did say if there was a finding of fact after a full-blown trial that you were a danger to someone else, you had to post a bond or otherwise, go to prison or lose your gun rights or things like that. So again, you have to, in the real world in which we live, this was the best possible decision we could get. Now, put this into context. Sometimes, folks, when you're in a war, losing less badly is a win. You got to understand that. It's whether it be sports or whether it be a war, you simply, as a general matter, don't win every battle. You're going to have to lose some. And what you want to make sure is when you have a losing hand, you minimize the damage. Now, the good news, in my opinion, in fact, I would argue this is great news, is that Merrick Garland took his best shot to destroy the Bruen methodology and came up empty. He failed. This is the major victory for the Second Amendment movement in Rahimi. I know some people criticize me for being too Pollyannish and too pro-gun control, which is kind of absurd. I understand that, but remember, I'm not talking to you about what I would want or what I wish would happen. I'm telling you about what's going on, in my view, in the real world, the good and the bad and the ugly, okay? So with that said, this is the best possible result we could get in this case, because Merrick Garland's entire goal was to give Elena Kagan and the liberals on the Supreme Court an opportunity to use a terrible set of facts with an allegedly terrible man who had done allegedly violent, terrible things to his girlfriend or wife, had been found to be problematic, who consented to the entry of this order, and all sorts of other terrible things. He had a hearing. There was some level of due process here, and he admitted and consented to all this stuff. These were terrible facts, and Merrick Garland pushed and expedited this case to the Supreme Court to make this the next Second Amendment case, as opposed to, let's say, the Range case out of the Third Circuit, which talks about a non-violent felon who's never hurt a kitten or anything on the record. That's not what Merrick Garland pushed to the Supreme Court. He pushed the Rahimi case, which is the absolute worst set of facts that the Second Amendment community could have, all with the intent to destroy the Bruen methodology of text first, burden shifting to the government, and then historical analog law analysis. The great news is that Merrick Garland, this is his best shot. He lost. The Bruen methodology of text first, burden shifts to the government, and the government bears the burden to show a longstanding historical tradition going back to the founding of longstanding gun-related regulations remains the law of the land. In fact, the good news is that even Justice Brown Jackson, the Joe Biden appointee, in her concurrence, said specifically that she admits that the Bruen methodology is the law. It is binding law in the United States today, even though she would have disagreed with it if she were on the court when it was decided. But even the liberals admit that the Bruen methodology is the law of the land. Now, this is hugely advantageous to the Second Amendment movement for several reasons. The first is it eliminates and reminds everyone that any form of interest balancing, gun bad, gun good, gun violence bad, gun blah, 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 good, self-defense, blah, 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 all that goes away. Now, it had already gone away in Heller, and it was reaffirmed robustly in Bruen that says interest balancing is a no-go. You can't go there. Merrick Garland wanted to bring all of that back to destroy the Bruen methodology, which is really the Heller-Bruen methodology of text and history. That failed. Interest balancing is dead as a doornail. It was dead as a doornail after Bruen. Merrick Garland wanted to bring it back with this bad set of facts, and he failed. Huge victory for us in that sense. Other great thing here is the entire decision rests on historical analysis where the burden shifted to the government, which means that, and this is going to be very important going forward with our licensing fights, that Rahimi, despite being an absolute, on the record at least, a terrible person, violent and whatnot, Rahimi is part of the people, as in the right of the people to keep and bear arms, that the Supreme Court implicitly found that he was part of the people. We know that he's part of the people because they spent the entire decision analyzing the historical component, where the burden is on the government to come forth with historical analog laws, which they said they succeeded with the surety laws and the affray laws, which again basically say you can't misuse a firearm to engage in violence and whatnot. So bottom line is that means these arguments that say that American citizens can sometimes be pulled out of the definition of the people, which is what the anti-gunners want. The reason why the anti-gunners don't want you and me to be part of the people is because, again, once a modern-day gun control law and your use of a gun is implicated by the text of the Second Amendment, the burden shifts to the government. And the government never, ever wants the burden to shift to them because it's very hard for them to satisfy in many instances, okay? So that is good news. Now, the other thing, and this is a very big win for us. Now, I know a lot of people are going to read the New York Times, and they're going to read the liberal press. They're going to be like, big win for gun control. Yeah, not really. Okay, if anyone in the liberal press says something inconsistent with what I'm saying, you can basically assume that I'm right and they're wrong. It's as simple as that. As a general matter, that's your basic assumption, okay? If someone's disagreeing with me, that's great. They can disagree with me, but, odds are they're probably not going to be correct compared to what I'm saying. That's my best assumption. You take it for what it's worth. That's my thinking. So here is a big win for us, okay? And again, you got to put this into context. We were trying to dodge a metaphorical bullet here. Merrick Garland was trying to destroy the whole methodology, bring back interest balancing, and next thing you know, if they had done that, it would be guns are good, guns are bad, and then they would unleash all these public health experts to talk about how guns are terrible and violent, blah, 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 the usual nonsense that the anti-gunners like to bring up, and then we'd be back in that world. The good news is that did not occur. This case rejected that outright. That's a big win. Now, the other major win here is they specifically address the abuse by the government about responsible citizens. Have you remember, like when we're dealing with licensing cases and all this, all the anti-gunners like to say that the Supreme Court says that you don't have Second Amendment rights at the textual level if you are not responsible. And then they quote a bunch of references to the Supreme Court's language that talks about responsible Americans, responsible citizens, responsible and law-abiding. The good news here is the Supreme Court, specifically in the Rahimi case, unequivocally said in their majority opinion that the word responsible is meaningless and vague and irrelevant when it came to Second Amendment analysis, which is what I thought was going to happen here, because they said they were using the word responsible in Bruen and Heller or in McDonald just as a general reference to the plaintiffs in those particular cases. There was no dispute. And that's very good, because one of the big weapons the anti-gunners uses against us today is to try to say that Bruen and Heller says that the only people that have Second Amendment rights are those that are responsible Americans. And then they go on to say, because you posted something about Donald Trump, or you said something bad, or you went to a school board meeting and complained, whatever it is, they view you as not responsible. Or they use that as an excuse to get, let's say, your medical records or to get your social media accounts, because they need to make sure you're a responsible American. But the Supreme Court in this Rahimi case just literally said that that's total BS, that the responsible language simply does not hold up. That is not part of Second Amendment law. That was pure dicta in prior cases. And going forward, it's not just about responsible citizens having the right to keep and bear arms. It's all Americans have the right to keep and bear arms. And only if there is a judicial finding that you are a danger to yourself, to others, specifically physical violent danger, then you can be disarmed temporarily. And here's the other word. The other key caveating this narrow decision was that you can be disarmed temporarily. The court repeatedly hammered this home, that this is about being temporarily disarmed while you are a violent danger. That is a big deal, because as you know, 18 U.S.C. 922G, as a general matter for most of those provisions, talks about a permanent lifelong ban on the possession of firearms. And the Supreme Court really emphasized here that what made 922G8 constitutionally allowed in some cases, not all cases, but in some cases, was, among other things, its temporary nature. So at some point when you're no longer dangerous, that temporary status goes out the window, and that's exactly what they said. So look very carefully to see how the word temporary gets used down the road. It could be used very favorably. For example, in the 922G1 cases dealing with nonviolent and other felons, at some point people are no longer violently dangerous. The temporary period is come and gone, and that is a big thing that we may be able to use as a weapon going forward from this Rahimi decision. Now, the last thing I want to talk about is red flag laws here. Now, this decision leaves open the red flag law question. I want to tell you what that means. Okay, I want to be very clear about this. Okay, red flag laws or gun confiscation laws can be constitutional, I think, and I think this has always been the rule, if they are analogous to, and what they really are, is the Florida Baker Act rules. In other words, if there is a full-blown trial where you have an attorney, or the government appoints an attorney if you can't afford one, you have a mental health expert, and it's a trial with witnesses and testimony, you have the right to confront witnesses that testify against you with lawyers cross-examined. If it's a full-blown trial of the same sort of thing, that at the end of it you are found by at least a clear and convincing evidence standard that you are a danger to yourself and others, and by extension, they could involuntarily commit you into a mental health institution. If there's a full-blown trial along those lines with robust due process, and you're found to be physically violent danger to yourself or others, then yeah, I think you could be disarmed under the Second Amendment in that circumstance. Now, this court specifically, this is very important that you understand this nuance. It's actually not much of a nuance. The Supreme Court specifically said in Rahimi that they are not dealing with the levels of due process that are needed before there is a finding that you're a credible threat of physical violence to someone else. They're not dealing with due process. And here's the key. The reason why they did not deal with due process in this case, they acknowledge it's a legitimate issue and that it's going to come up down the road, but they said that Mr. Rahimi, in this case, had waived his arguments about due process, that he did not argue that he was denied due process, nor really could he, because remember, he had a hearing, he testified, I believe on the phone, he admitted to some of the stuff, he conceded and agreed to the entry of this order that he then challenged. So the point is, that was not a very good due process case when you show up and you admit to everything and you concede to everything and you agree to the entry of the order against you. Not the best due process facts for us to bring a legal challenge in the Second Amendment community, right? So that Supreme Supreme Court says specifically here that we're not getting into what due process is because it wasn't raised in this case. It will have to be dealt with down the road. And I think the right answer is ultimately going to be, again, if it's a full-blown civil commitment, a civil involuntary commitment process of the sorts we see called Baker Acts or whatnot across the country, I think under those circumstances you can be disarmed because they can put you in a mental institution because you're literally a danger because you're mentally ill. And that does happen. There are people that really need to be put away because they're mentally ill and they're dangerous to themselves or others. It does occur. Those people are out there, right? Okay, so with that said, this Supreme Court does not endorse in any respect red flag laws. All they've done is that, again, if there's a finding, what that finding is, the due process associated with the finding has not been determined, but that is where we are. Okay, so we're going to do a lot more on this case, a lot more analysis here, but the bottom line is this. Do not kid yourself. This was an extremely dangerous case for our Second Amendment rights. And Merrick, Garland, and Joe Biden knew exactly this. They're not stupid. They may not be good Americans, in my view. They may not respect the Constitution, in my view, but they're not stupid. They're high IQ individuals surrounded by highly intelligent people and great lawyers. They know exactly what they're doing. And that is why the Biden administration and Merrick Garland shoved this terrible, crappy Rahimi case to the front of the line, as opposed to other much more favorable fact patterns in support of the Second Amendment. But they had their shot. This was their best shot to win the Second Amendment wars right here and right now in Rahimi, and they failed. Take solace in that. Be happy about that. We always got to keep fighting. We always want more. We always want to win. But the good news is we avoided a major defeat in this case with some positive news. Again, I'm not being Pollyannish. I'm not just blowing smoke up your dupe or anything like that because that's what I do. No, I'm not doing that. I'm telling you right now, we really dodged a bullet here. We should be happy about this. And now we got to go on and march forward with a lot more work. We all have a lot of work to do. And I'm going to continue to work here on the Four Boxes Diner channel. So there you have it. Again, you'll probably see me in the press and on Fox News. I think I'm supposed to be on there tomorrow morning at 1 o'clock. Fox News channel. That's I think where I'm going to be. So anyway, there you have it. Make sure you subscribe at Four Boxes Diner. Don't forget to follow me on X at Four Boxes Diner as well. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.